an ape, a cat, and a punk have in common? They are worth millions of dollars in NFT marketplace. Nyan Cat sold for almost $600,000. A mini collection of the Bored Ape Yacht Club, popularly known as Bored Ape, sold for $24.4 million. And one CryptoPunk alone sold for $24 million. From art collectors to millionaires to companies, everyone is trying to catch the NFT train. But what are NFTs? A non-fungible token or NFT is a digital object such as GIF, music, art, in-game article, photos, videos, or even social media posts, and virtual assets such as land, shoes, clothes, etc. with unique digital tokens that can be authenticated via blockchain technology. It cannot be duplicated or is not interchangeable. The simplest way to think about an NFT is to consider it a digital collectible that is one of its kind or at least very exclusive. The history of ownership, the authenticity and the origin can be verified on the blockchain through platforms like the Ethereum, from smart contracts, which are software codes that are authenticate the ownership and regulate their transferability. The first NFT was created or minted in 2014 when Kevin McCoy created the Quantum using a technology he developed with coder Anil Dash. In 2021, Quantum sold for $1.4 million. This is a mere fraction of the $69 million that digital artist Beeple got for his NFT titled Every Days, the first 5,000 days. However, Vignesh Sundaresan, a Singapore-based cryptocurrency investor who brought Beeple's NFT, received rights only to display the artwork. Beeple retained the copyright and reproduction rights.
So that brings us to the question, what IP rights does an NFT provide? Broadly, the IP involved in NFTs will be with respect to copyright and trademarks. We have seen many big companies protecting their marks in the relevant classes through trademark registrations. Brands that have sought protection are Nike, Crocs, Ralph Lauren, Gap, McDonald's, to name a few. Buying an NFT does not necessarily mean you own all the rights in it or the right to use it for commercial purposes of your own. As we have seen with Beeple, a seller can retain his copyright and right to reproduce the work as he wants. Smart contracts can have different clauses embedded in an NFT that could automatically execute certain actions such as payment of royalties with each subsequent sale. Copyright issues can also arise as the very authenticity of the NFTs can be in a question if the initial entry in the blockchain is false or has errors. Nike, which has filed trademark applications for virtual goods, has sued StockX, an online retail marketplace, for infringement of its trademark in the virtual space for selling Nike sneakers as NFTs. Its lawsuit claims that the StockX is using Nike's trademark and goodwill to sell those NFTs at heavily inflated prices. Another relevant example is the recent dispute involving luxury brand Hermes and the digital artist Mason Rothschild. The brand has taken Rothschild to the court for minting and selling 100 NFTs of its Birkin bags, which Mason Rothschild has termed as Meta Birkin. When copyright in NFT will get transferred or assigned to a buyer, and to what extent copyright or the IP rights in a work will be transferred can be covered in the smart contract. In the absence of any explicit term of assignment in the smart contract, the buyer will have limited rights. As more brands like Gucci, Bulgari, Dolce & Gabbana, and Jimmy Choo continue to launch NFTs on various platforms, brands should review their existing trademark applications and registrations in order to determine if the classification of goods or services provide them with coverage for NFTs and digital fashion, and if not, brands should explore this new space to protect their IP rights. A lot is happening in this unique space, and it will be interesting to see how this space shapes up in future.